Abdin. I'm an immigration attorney here in Central Florida, and we are going to be discussing wills, trusts, and estates. So I have brought in a legal guru, if you will, Zubair Dawood, an excellent attorney and an exceptional friend as well. Zubair, if you would, please introduce yourself.
Thanks, Yaz. Thanks for inviting me. I appreciate it. Thank you for the opportunity. Like Yazin said, my name is Zubair Dawood. I'm an attorney here in Central Florida. I practice multitude of areas from business transactions to real estate to estate planning. I graduated from University of Florida. I've been a Florida native basically my whole life. I was born and raised in Orlando, so I've been in the community for a significant period of time. I love Florida, love everything Florida. So thanks for having me.
Absolutely, absolutely. So Zubair, tell us about your wills, trusts, and estate practice. How did you get into that?
Well, but it kind of happened by accident, to be honest. I was looking for practice areas of what I should specialize in or try and open myself up to. And I actually was contemplating getting an estate plan done for myself. And I reached out to a couple of attorneys. I had some discussions, and from that point, I was like, it seems like it's something that you can really help people with, especially when it comes to wills, because there's certain things that you can do in wills that actually help protect families, and one of those being guardianships. In wills, you can actually, especially if you have underage children, you can designate guardianship, and that's something that's very important because you don't want to leave that into the hands of the state. God forbid you or your spouse or your significant other passes away and you haven't set out guardianship. You really don't want the state to be in the position to say that this is the best benefit. This in another set of parents or another individual is the best for your child. So that's something that I really, it hit home for me. So.
And so, wills, trusts, and estates, is that state specific?
Yes.
Okay.
So every state has there's like general guidelines that I guess usually states follow, but every state has its own unique, rules of construction and things of that nature.
So, right now we're going through a pandemic. We're going through COVID-19, global crisis. And anytime we have a global crisis of any kind, whether it's a tsunami, earthquake, pandemic, whatever it may be, and death is prevalent, people start to think about their assets, what they own, anything like that. So now that this is an important topic, have you seen a flux in your wills, trusts, and estates work?
We've definitely seen an increase. One of the things that we do see more of is things in the estate planning. I guess the sphere would be more of like the living will and healthcare surrogate side. So what that is basically, you're able to designate how you want your end care to be. So you can designate an individual to either make healthcare decisions for you. That's one of them, and the second is to designate where you want healthcare to stop. For example, if you do not want, if you're in a vegetative state and you do not want extraordinary measures to, happen after that point, or if there's a specific point, we have documents, or you can draft documents to basically say to that fact that you do not want care after such and such point. Okay. And those are important things to have, especially when, if you don't want to live on a ventilator for 2 weeks. If you're in a certain state, and at that point the doctors don't think they can bring you back, or the chances of you coming back are very slim, you've already designated that I don't want that additional care, just to let me be comfortable and let me pass naturally.
So let me ask you this, in the state of Florida, if someone is on their deathbed, are they still able to get a will done at that time?
One of the biggest factors of wills is capacity. So if somebody has what the law deems as capacity and the ability to know what they are doing and they have full capacity, then yes, you can do it. It doesn't matter if you're in it doesn't matter as long as you have capacity. So if you don't have capacity, you cannot. So that's why they even said there's some cases we looked at in law schools, like if you have somebody that has Alzheimer's or some sort of degenerative cognitive disability or disease, if they have periods of lucidity and during that lucidity, they actually create an estate planning document. As long as at that time, when they signed those documents and those documents were done, they were lucid and they had that capacity, then that it would still be an effective document. So that's the biggest key word would be capacity.
So best practice would be not to wait until you are in a position where you need the will or the trust to get it done as early as possible would be the smart thing to do.
Absolutely. It's better to always plan these things out because you never know when that time is going to come where you won't have the capacity. A lot of the times we see clients that they want to have healthcare directives when their significant other is already in that state, where they're already they're in the hospital, they're in a coma, they're unconscious. At that point, there's not much you can do. Or they come to us for a power of attorney. Because at that point, there's not much they can do with their assets. If they have if you keep separate bank accounts between you and your spouse, and your spouse doesn't have anywhere on that bank account, the bank's not going to allow you to have access to those funds. So it's important that we plan for those scenarios. And if you need a power of attorney document, it's not going to happen. It's not going to come out of nowhere that right when you need it. Oh my such and such we'll do it right now. Usually at that time when you really need it, you won't be able to do it, unfortunately.
Right. So most of our listeners are Floridians, naturally, because we are located in beautiful Central Florida. So one of the questions I've received from the guests are, if I were to die intestate, in other words, meaning without a will, in the state of Florida, generally speaking, what happens?
So what we have in Florida is called intestacy statutes, which set out how property or how assets would be transferred to someone's heirs. So heirs would be basically the beneficiaries, meaning if you have children, generally speaking, those would be considered your heirs. So Florida has guidelines as to how the assets would be distributed. But in order to get those assets, you have to go through a process, what's called probate. And depending on the size of the assets and the size of the estate, there's certain levels of probate, meaning you could have something that's called summary administration, which is a little bit quicker and easier. Then you could have actually a full probate, which is a little bit lengthy, more expensive process to go through. And basically through that process of probate, the judge designates what they call, what they call the personal representative of the estate, and that individual will be tasked to get the property, transfer the property, and give it to the appropriate heirs according to the state of Florida.
Okay, very good. Another common question that comes up is, what is the difference between a will and a trust?
So basically a will and a trust, they're similar in certain ways. A trust, you can have a testamentary trust, which kind of, I want to say, acts as something like a will, but it's not. It's what we call a will substitute almost. And a will is something that you can use. Anyone can use a will. Anyone can have a will. Anyone can use a will. One of the things, again, that we had kind of discussed on earlier that is unique to a will is the issue of guardianship. In a trust, you're not going to be able to designate guardianship. So there are differences between it. So no problem. The trust, the primary purpose of a trust is to avoid the probate process. So that's why we want trust. We don't want to go through the process of probate. Probate is a lengthy process. It's a public process. You can look things online when it comes to probate matters. And so a trust allows you to do that in a private way. A trust is a private document between several parties, between the settlor, between the trustee, and the beneficiaries. So if you're creating a trust document, you would be the settlor because you are the one who is putting the assets into the trust. Say you designate me to be a trustee, that means you're charging me with the task of distributing the assets as you have written down in this trust document that we set out. Beneficiaries would be your family members or whoever you want to give that property to. So you're entrusting me with the duties of giving those assets to those who you've designated. That's the trustee's role. And that's what how a trust works. And there's definitely in intricacies and complexities that you can add, and you can do things with A trust that you have a little bit more leeway than maybe say in a will.
Now, correct me if I'm wrong, with a will, it only kicks in after death, but with a trust, it can be effective during your lifetime.
Depending on the trust and how you're setting it up, yes, that could be true. So you can have basically a trust you set up right now. Well, you can have what's called a revocable trust and an irrevocable trust. A revocable trust is a trust that you can modify, change, you can revoke it during your lifetime. A will, you can do similar things as well. But throughout the life of when you have a revocable trust, you can change things. Say, for example, you want to modify. Say you want to give me that $1 million that you were going to give to your son. Say that's going to happen. You want to change me and you want to put me into it. You can always make changes to it. You can modify it. You can add stuff to it. You can remove things from it. You can rip it up and get rid of it, undo everything you did, and pretend like you didn't have a trust. But a trust actually it's almost, I don't want to use the word entity because a revocable trust is not something that you have to register, but it acts like almost an individual. So you have a trust, you can transfer things into it, take things out from it, but to undo it, you have to take necessary steps. Whereas in a will, you don't do anything of transfers.
Okay.
The transfers in wills happen upon death. So upon death in a will is that when you know, okay, so there's certain property, if you have what they call a specific bequest, meaning you want to give certain things to individuals, and you lay that out in a will. So if I wanted to give something, say in my will, I say I'm going to give Yaz that $1 million back. And so in my will, I say to Yaz $1 million. That's a specific bequest.
Mm-hmm.
So that would go directly to you in my will upon death. But there's that process that we have to go through. So if there's property that has to be probated or there's assets that need to be probated, we'd have to go through the court system in order to make sure that those assets will transfer.
Okay, excellent. Two-part question from our listeners.
Sure.
Can anybody create their own will? That's part one. And part two is, if yes, what are the basic requirements of a will in the state of Florida?
Yes, you can create a will by yourself. There's no prevention of someone doing that. But there is, in Florida, there is specific rules for executing a will or to make it effective. And that's one of the main things that you have to make sure that you follow. And those is that you have to have two witnesses and they have to sign, and the one who's writing the will must sign in front of those witnesses. And it has to be contemporaneous. And so they have to also know that what you're signing is a will, and they have to be aware that what the document is. Right. So there has to be that understanding between the parties that, yeah, this is my will, I'm signing my will, and you're testifying that, yes, I am signing, I am witnessing to your will.
Excellent, excellent. And the final question we have for you,
Sure.
Attorney Dawood, is if someone wants to get started and to create a will, what can they expect? What's the process like? So they call your office, they schedule an appointment. What happens next?
So generally when we have a consultation, we just kind of go over your personal assets. We kind of go over what you're trying to achieve and your objectives, because depending on each individual's or each client's objectives, we try and tailor an estate plan that fits your needs. So if we look and see how your assets are currently set up, how do you have your property set up, how do you have your bank account set up, how do you have your investments set up? And once we see and we understand your full picture, we're able to say, hey, or recommend to you that this may be the best suited for you. So if a trust is best for you, we would advise you, given your circumstances, that a trust may be the best for you. Or given your circumstances, maybe a will is best for you. It all depends on each individual circumstance, but the information that we gather is just to find out what you have and what your objectives are, so we can help achieve those objectives in the best vehicles possible.
And a follow-up question to that final question,
Sure.
What's the timeline look like duration-wise? How long is the turnaround for a trust versus a will?
Usually when we do trust, we also incorporate wills as well, so we do everything almost together. Usually it doesn't take longer than a week or two, just depending on, again, that's the general rule. If it's very complex, it could take more time. If it's very simple, it could take less time.
Excellent, excellent. Well, hopefully the viewers find this helpful, and please share your contact info one more time so that they
Sure.
can get in touch with you.
Yes, so the best way is by email. The email address is Dawood, DAWOOD, @Dawood, DAWOOD, Sohail, SOHAIL, law.com.
Thank you, Attorney Dawood. Appreciate your time.
Thank you, Attorney.